In New Jersey, the cost of assisted living can reach a staggering $10,000 per month, doubling to $20,000 for both mom and dad. Nursing homes, even higher, at $15,000 per month each. One area that is often misunderstood is the 5-year look-back period. Let me explain what this is and why it's so important. When it comes to elder law planning, it's important to work with experienced and reputable specialists who follow ethical practices. The reality is, only time will tell if a plan will actually work. I see lawyers getting this wrong. People who work with senior citizens all the time get this wrong. And I want to set the record straight because this misunderstanding, while seemingly very simple, is leading to the financial ruin of families unnecessarily. In this video, we're going to dive deep into one of the most important yet misunderstood aspects of elder care planning. This is the unbiased explanation I wish I had before I had to scour the country for the truth. I'll explain exactly what this is and why it's so crucial when it comes to protecting your family's hard-earned assets. I'm not an elder law planner, I'm not an attorney, but I have some of the best information for you to help you make an informed decision. The underlying message is Medicare is not going to pay for much. Medicaid will pay for 70% of long-term care bills in the country. And the same is true if we take our example that I'll use in New Jersey. You'll learn about the different ways people pay for long-term care costs, the strict asset and income requirements to qualify for Medicaid, and the penalties for improper transfers. We'll explore ethical legal strategies like utilizing irrevocable trusts that can help qualify for Medicaid while preserving your assets within the guidelines. You'll get real examples illustrating the complexities involved, such as the capital gains tax implications of transferring a home. Also, we'll touch on other advanced techniques like reverse mortgages that may be options depending on your situation. By the end, you'll have a clear understanding of the 5-year look-back rules and the risks of improper planning and the professionally guided paths available to protect your family's future care and financial security. Here's why. Unless you have a crystal ball, no one can predict the future. So we can't be certain how long a plan will hold up, especially when it involves federal programs administered by the states. The Medicaid look-back period, simply put, is a 5-year window during which Medicaid scrutinizes asset transfers. If they spot giveaways, expect penalties that could jeopardize your long-term care. It can be very valuable and help you to pay for care at home in an assisted living facility or in a nursing home. There are essentially 5 main ways to cover long-term care costs: private pay, long-term care insurance, limited Medicaid coverage for skilled home nursing care, and lastly, Medicaid for those who qualify for it. Mostly to qualify, it's financially eligible. However, these Medicaid and Medicare coverage rules prioritize costs over extended care. So there's some confusion over the 5-year rule for Medicaid. It's also referred to as the Medicaid 5-year look-back period. A lot of people don't know what it is, and they're a little bit confused. To qualify for Medicaid, you must meet strict income and asset limitations, typically no more than $2,000 per month in countable assets for an individual. And most people have more than that. And what a lot of people decide is that they're going to do all this, and then they think they can engage in their own Medicaid planning without hiring an attorney. And they say, well, I'm going to just give all my money to my children and then I'll qualify for Medicaid. I'll have my nursing home paid for. However, this assumption is incorrect and can lead to significant penalties. To prevent people from improperly transferring assets to qualify, Medicaid has implemented a penalty system. When you're applying for Medicaid, it will be assigned to an agent and investigator, and they will look at your bank transactions and any significant transactions. And you also have to swear under penalty of perjury that you have not made any gifts over the past 5 years. Gifts mean a transfer of money or property without commensurate value. While improper transfers can lead to penalties, there are legal and ethical strategies like using irrevocable trusts that can help protect your assets within the Medicaid guidelines. As an illustration, I'll talk about a legal and ethical way, all within federal and state guidelines that allow to protect those assets and qualify for Medicaid. There are a set of strategies involving an irrevocable trust where we can take advantage of the fact that the law only looks back 5 years. When you transfer assets to an irrevocable trust, you effectively give up control over those assets. This can be beneficial for Medicaid planning because assets in an irrevocable trust typically aren't considered to be your personal assets when determining Medicaid eligibility. And there's a way to get people with substantially more money to get a lot of assets out of their name and then wait 5 years before they're closer to qualifying for Medicaid. For illustration, in New Jersey, MLTSS, also called Managed Long-Term Service and Supports, refers to delivery of long-term care services through managed care organization. The important criteria in determining eligibility for MLTSS are healthcare status, current insurance need, income, and resources. Approval for MLTSS is a two-pronged process. An applicant must be medically and financially eligible. Medicaid will send a nurse to assess whether you are living in your home or in a facility to see if you meet the nursing facility care, which is defined as needing assistance in 3 or more activities of daily living. Financially, the individual must meet the income and resource test. The income limit could be $2,000. However, if the applicant gets over the income limit, they can use a qualified income trust to qualify. The resource limit for a single person in New Jersey is $2,000. Some resources, such as the home you live in or one automobile, are exempt. There are additional complicated rules for both income and resources where there is a spouse. I want to talk more about the Medicaid 5-year look-back period. For illustration, mom and dad, the unique and complicated parts of MLTSS eligibility is the look-back period and the transfer penalty. When an individual applies for Medicaid, they must provide bank statements for the look-back period. If there has in any way been an improper transfer of assets during the look-back period, a penalty will be imposed. If an application for Medicaid happens because you need state insurance to pay for nursing care or assisted living or other types of long-term care, or an application within 5 years of making a gift or a transfer for less than the fair market value, then you will be given a penalty. The dates are important for the gift or the transfer, and also the date you submit an application. If there is less than 5 years in between those dates, then you will be given a penalty period. If any gifts transfers are made within the 5 years of applying for Medicaid, a penalty period will be calculated based on the amount of the transfer, prohibiting you from receiving benefits for a set number of months. Unfortunately, the penalty period does not start until you qualify for Medicaid. For a single person, you have to be down to $2,000 per month, and you can own a home and one car and a burial expenses in a trust or an insurance policy. Planning around this penalty is very important regarding trying to access Medicaid and getting care that you need paid for. For illustration, for a married couple, each 74 years old, for example, Medicaid has a set of allowances. The institutionalized spouse can only keep $2,000, while the community spouse living at the home can retain a portion of the joint assets up to around $130,000. That's the maximum. So if they had $200,000 of assets, mom can only keep half, which would be $100,000. If they had $400,000, she can't keep half. There's a maximum of around $130,000. And all these numbers are indexed to inflation, and they change every year, depending on whether you're single or married. But a single person has to stay under $2,000 in assets. But the real devil in the details there is because different assets are treated differently. We have countable assets and non-countable assets. I want to just walk you through some of the more common assets that typical people own. I'm married. I have $300,000 a month in income, but I'm a little bit over this monthly limit. In New Jersey, you can do something called a qualified income trust. The concept is to take your excess income and you assign it irrevocably to a trust. So generally, the problem is the person is receiving income from Social Security and the pension. Usually the Social Security is under the cap, but the pension puts them over the cap. You only need to do one thing, which is assign the pension to the qualified income trust. Then it doesn't count as income. Typically, you would have one of your children, the trustee of that trust, every month would then put money in, and every month they would pay the facility or the home health care agency. And that solves the problem. Sometimes people have Social Security, which puts them over the cap. If they have a pension under the cap, then you would assign a Social Security and keep the pension. Sometimes you have Social Security but no pension, but the Social Security puts you over the cap, in which event you have to sign the Social Security to the trust. We have a home in New Jersey and land in Virginia. We could put both the home and the land in separate irrevocable trusts. We would have to get a Virginia attorney to work with the New Jersey attorney in that example. A couple of things. Medicaid is a federal program handled by the states. Every state and country is a little different. In Bergen County, for example, the Medicaid office is very strict. There are certain things that don't fly, even though they're supposed to. Then, for example, in Warren County, they are a little less strict, but we don't take any chances. We could also do a tax freeze. There's a tax freeze that's based on income, and they can keep it if they transfer it to the trust. So the way the transfer works is set up the trust. It's a guarantor trust, and you can retain all those benefits. The deed going into the trust says mom and dad reserve the right to use and occupy the property for the rest of their life or lives, and they will pay all the expenses as long as they're living there. So frequently people do that when they're 75, or for, in our example, 74. They don't have a diagnosis. It really doesn't affect them in any way because they're still living there. Their taxes are paid for and all their expenses are handled. One important consideration when transferring a home to an irrevocable trust is the potential to capital gains taxes that may be owed if selling the home down the line. If parents put their home in a trust and they purchased it for $100,000, will sell it for $600,000, there's a $500,000 gain. They don't get the exemption. One key consideration when transferring a home to an irrevocable trust is the potential capital gains tax implications. Let me explain this with an example. So the trust would now have to pay capital gains taxes of $100,000. Now, if our plan worked and we saved the whole house from Medicaid, then paying $100,000 when you sell the house doesn't feel bad. If parents, for illustration, never need Medicaid and we put it in there, then they both die later, or we sell it, then they never need Medicaid. It's going to hurt to pay the $100,000 worth of capital gains taxes. Remember, we can't predict the future for long-term care, but it's a pretty good strategy. In New Jersey, we have something called a homestead tax rebate. If your income is below a certain level, then the state sends you a check. You can keep that check, and if you do it right, you can set it up in a trust to keep it. There's another plan here that we can layer on top to say, okay, we're going to put the house into a trust and we're going to keep the life estate for mom and dad. They're never going to move out of the house. We're never selling that house until they pass away, because after they pass away, the house would get revalued for government purposes and for tax purposes. So to say, well, since they had a life estate, it's like they owned it for tax purposes, and now it gets revalued to step up in basis. For example, it's as though they paid $600,000 for the house. Now the trust sells it for $600,000. There's no capital gains tax. So we can plan. We just have to make sure everybody understands the pros and cons of the plan. The hypothetical starting number I gave is $100,000, but I don't put any of those extra flourishes in. Now, our parents didn't do a whole lot of work to their house, but they certainly put in some capital improvements over 30 plus years, because whenever they paid something, they had redone the bathroom, they had redone the roofs, that all gets added into the $100,000 they had paid. Over time, maybe they put in another $100,000 worth of capital improvements. Now the government would say, well, their adjusted base is $100,000 basis. They paid that plus $100,000 of capital improvement. Now that's $200,000 basis. They sell it for $600,000. So that's about a $400,000 gain. When I'm doing my illustrations, so it's a 20% capital gains tax rate, but it's just for illustration to show you how it can really impact. Another example, now if your parents just happen to have sold their original home and now they move into a different brand new home, they just paid $600,000 for that new home, then it's a whole different analysis. It makes it a whole lot easier to decide now. We might lock into $100,000 capital gains tax. We know we're going to have to pay it. And then when we sell the property, that's when we realize what we paid and what we have to pay. Or if it was a brand new purchase of their home, we just brought it for $600,000. So yeah, we'll have to pay some capital gains tax, but it's not so high of an amount in taxes. In addition to irrevocable trusts, there are a few other advanced techniques that may be options depending on your situation, such as reverse mortgages, which is they took a reverse mortgage and got out $300,000 from the house, and they took $300,000 cash and put that into the trust. Then they live basically. They are now not paying any mortgage. They just have to pay their taxes. But when they sell the property, they get less equity out of it because we took the $300,000 worth of reverse mortgage money. But they won't have to pay any capital gains tax either. Ultimately, the ideal planning strategy will depend on the parent's expectation and assumptions about their future care needs. However, since no one can predict the future with certainty, it's wise to build in flexibility. For another illustration, you could have a family. They never expected the parents to move out of the house until they died, but the parents need so much care that they can't stay home. So now they're faced with capital gain. It has a significant impact on their taxes that's negative. I want to make sure you understand it before your family makes a decision. It's a complicated decision for many families. For example, people like our parents who paid so little for their home because they've been living in it for 30 plus years, it can be a huge amount of money. But still, if you compare it to, but if we had it, we would have lost the whole house to Medicaid, then it's still a better plan. And then the other thing we would make sure of is if the parents have the proper documents in place. Do they have the right kind of power of attorney, the right kind of living will? Or do they have that already? Let's say they have a will and the power of attorney. When I say the right kind, it means it's broad enough and it allows you to handle things that need to be handled. Ask, who is the agent for the power of attorney? Then ask, who is the backup power of attorney? Just make sure everything is done and your parents are protected for all the possibilities. And that's what the power of attorney is, and the health proxy is all about, and the will. For illustration, they have a will that says everything to each other and then to the children. Once you get the base plan done, then we can add on things that might make it a little better. For some children, when they talk to their parents about doing this, they would not give up control of their house. The parents don't like to give up their home, or the potential capital gains tax consequences are too much for them to deal with. Another example for some people in their 60s and 70s is they feel like they're going to run into the Medicaid issue. They're 74, maybe they're in good health now. I like putting the house in an irrevocable trust because it doesn't change their quality of life at all. They're going to live in the house, everything's going to be fine. Then we're going to start today, for example, for 5 years from now. Let's say it's April 1st, 2029. That 5-year look back we talked about. In the event that this trust is set up, let's just say we get it all done today. The home would be in that trust until essentially April 1st, 2029. Before it would have that full, complete protection being considered an asset for Medicaid purposes. If one parent ended up having to be admitted before the other, then there's some spousal exemptions for the community spouse that could apply. But in the event both of them need this level of long-term care prior to that 5-year look-back period, then that point in time, we would be running into some issues because that would essentially be a transfer for less than fair market value. So there's a couple of nuances with irrevocable trust. The first right one is the name. It's irrevocable. Once you set up the trust, you fund the trust, such as deeding a property out of the individual's name into the name of the trust. That's not something that can necessarily be undone. That's the idea behind it. It's set up to work this way to offer those protections from Medicaid, this being considered a resource. Now, the property that's in the trust can be sold pursuant to the substitution of the asset clause in the trust, but the cash does not go back into the hands of our parents. In this situation, it would go in the name of the trust. Now, the trust can use the money to buy another home, but nothing would end up going back in the name of our parents. Another little kicker is the trust that is in our parents' name. They would not be able to be the ones responsible for managing the trust and its assets, meaning they don't have control over their own home anymore. That would be the trustee that they can then choose to appoint. Although the word is right there in everything, trust is a big factor. Trust. They likely appoint someone they trust to serve in the trustee role and would like to operate under the idea that the trustee is not going to up and try to sell the house underneath them, because they do have a fiduciary responsibility to both the settlers of the trust and of the trust, which would be our parents and the future beneficiaries of that trust, who our parents decide the proceeds of the trust should be distributed at their passing. And ultimately, this trust would be a mechanism for the land in Virginia. It would just be like what we had to happen here in New Jersey, and that the property is deeded out of the individual's name and deeded into the name of the trust. And that 5-year look-back period would apply in any situation to offer the protections of that trust. And ultimately, outside of that, when it comes to the property itself, it's not something that requires a lot of day-to-day management. From the trustee point of view, when it comes to bills, property taxes, the normal average everyday carrying costs of the home, those can continue to be paid by our parents as they are in the living of the home. They don't have to be shaken up and can remain the status quo just because the property is now in the name of the trust. It's just that they no longer have the control or the decision-making power over the property. Because with this irrevocable trust, Medicaid looks at it. What do they have control over? Do they have control to say, to sell the property, give the cash, or what do they want to do with the property when it's converted to cash? In this trust, it is a discretionary trust, meaning they can't make any demands of the trust. They can't say, give us the money or we're going to sell the house. They can't say anything. So what the trust is at their discretion to make payments on behalf of their bills and other items that they may need. They can't be compelled to turn that money over to anybody until ultimately what the action of the event of the trust is. And that would be at the time of both of them passing away. Then it would be able to be distributed to the beneficiaries of the trust. Now, it would be the property in Virginia. We would need to do another whole irrevocable trust for that. With a Virginia attorney, you wouldn't necessarily need to do that though, because alternatively, you could recommend to consult a Virginia attorney. Most would say the trust crosses state line. It would just be the deed that would be the need to likely be prepared by the attorney in Virginia. The trust is the legal entity that's going to take ownership of the property. That's the kind of control that it has by its own guidelines and within the confines of the law, but controlled in its own terms. You could put multiple properties into the trust, and that would offer protection for those multiple properties. But with that spousal exemption that we're talking about, if one of them needed to go into care before the 5-year period hit, then they only offer that spouse exemption on the primary residence. The Virginia property would not be offered the same exemption, and that could potentially run into some issues with the transfer for less than the value of the property, which could result in a penalty depending on the value of the property and the time frame of everything. Ultimately, I would sit down with or be on some sort of conversation with our parents to go into detail and address the questions they may have about the trust, because it is their property. And sometimes people can be apprehensive about giving that away and releasing the ownership control. But once they are able to handle that and handle the deed preparation and have everything essentially put together and filed properly, once that deed is signed and dated, then the protections start and the clock starts ticking from that date for the protections. So in general, we just need one irrevocable trust, or they don't necessarily need two. They would just need the deed to be in Virginia, for example, to be inside of that trust also. If you don't do it in that way that I'm demonstrating, find a specialist that is certified in elder law, or they have been doing this at least 20 years. Qualified elder law attorneys typically charge substantial fees of $7,500 plus for drafting the irrevocable trust, and that's for each trust. But you can find them for below even $1,500, but ultimately $1,500, you get what you pay for. I don't necessarily like to badmouth or talk about anybody else's fees or rates, but I know what is fair and what is considered fair market can sometimes be two different things. The fee for a trust is $800, and that would include the initial consultation and then when they have everything signed. If the specialist would be doing the deed as well, that'll be $350. So it would be $1,150 for the document. And then you'll need 2 appointments likely, and 2 appointments to get that done are included in that. It would be just one trust and the deed. There's a recording fee with the county, which is like $85. Then depending on if they want other estate planning documents, those would be on a per document basis. Power of attorney, living will, medical directive. Prices could vary. If anybody is receiving disability benefits and is on special needs, that's a potential beneficiary because there's some extra items that may need to be addressed in that situation. But generally, the trust, deed, and recording fee altogether is generally below $1,500. How most attorneys do it is they'll send you a fact finder or have a phone call where they gather the information, you get the documents prepared. You could do a lot of it virtually and remotely. In this illustration, it's just really up to our parents and what they want to do, what you think is best, and how you can make them feel comfortable with everything. You should review the whole technique and make sure everybody's comfortable with everything and it's signed. Once it's signed, then you transfer the property into the trust. The trust has to pay capital gains taxes. Seek professional legal advice to ensure that an irrevocable trust aligns with your specific financial situation and goals. Navigating the complex world of Medicaid eligibility and asset protection requires careful planning well in advance. The 5-year look-back rule is a critical component that cannot be overlooked or underestimated. Improper asset transfers can lead to lengthy penalty periods, delaying access to crucial Medicaid benefits when you need them the most. However, there are legal and ethical strategies available, such as utilizing irrevocable trusts, that can help protect your assets within the guidelines. While advanced techniques like these involve nuanced considerations around taxes and Medicaid income asset tests, they provide a pathway to securing your family's future and the care of your family without total asset depletion. The key takeaway is this: don't wait until it's too late to start planning. Seek out experienced elder law professionals who can evaluate your specific situation and help develop a personalized plan tailored to our needs and goals. I've added a list of specialists I've spoken with in the link below. The proper preparation and the right asset protection strategy in place can get you the peace of mind knowing your hard-earned assets are safeguarded and your long-term care is accounted for. Take action now, as the consequences of delaying improper planning can be devastating. Protect yourself, your family, and your legacy by making informed decisions today. Your future self will thank you.